Hello everyone, we are the Group 3 and today we will discuss the Unit 4 entitled The Philippine Criminal Justice System and Human Rights. This unit has 4 lessons. First is Introduction to the 5 pillars of the Philippine Criminal Justice System. Second is Examining the 5 pillars of the Philippine Criminal Justice System. Third is Human Rights in the Philippine Criminal Justice System. Rights to due process, rights against illegal searches and seizures, rights of suspect under custodial investigation, and rights against unlawful arrest. And the lesson 4 is only the continuation of lesson 3, which is human rights in the Philippine Criminal Justice System, rights of the accused, right to bail, right against excessive fines and cruels and inhuman punishment, and rights against double jeopardy. So let's start.
Good day everyone, I am Lea Oliva from BS Grade 5. So before we start to the lesson, I am going to discuss first the overview of our topic. This lesson focuses on the 5 pillars of the Philippine Criminal Justice System, as well as the human rights issues that arise as a result of them. All aspects of Philippine criminal justice system are thoroughly discussed. The necessary steps are included, and relevant learnings thereof are elaborated. This unit also discusses important aspects of each human right. In the end, you will realize that human rights exist, are important to the Philippine criminal justice pillars, and are important to your understanding of the entire subject of human rights education. Definition of terms. What is criminal justice? Criminal justice is a generic term that refers to the laws, procedures, institutions, and policies at play before, during, and after the commission of crime. What is Philippine criminal justice system? System or process in the community by which crimes are investigated and the persons suspected thereof are taken into custody, prosecuted in court, and punished, and if found guilty, provisions being made for their correction and rehabilitation. So now let's move on to the types of crimes within the Philippine criminal justice system. There are about 18 types of crimes as specified in the Penal Code and other laws. Crimes against national security and law of nations, crimes against the fundamental laws of the state, crimes against public order, crimes against public interest, crimes related to opium and prohibited drugs, crimes against public morals, crimes committed by public officers, crimes against person, crimes against personal liberty and security, crimes against property, crimes against chastity, crimes against civil status of persons, crimes against honor, quasi-judicial offenses, special crimes as provided for under special laws such as carnapping, hijacking, and plunder, violations of city and municipal ordinances, crimes handled by special courts such as corporate crimes, heinous crimes, intellectual property rights violations, and violation of forestry laws, crimes under the jurisdiction of the barangay justice system. And now, let's proceed to the 5 pillars of the Philippine criminal justice system. The first pillar is the law enforcement. Law enforcement involves prevention of the commission of crime and the protection of the life, liberty, and properties of citizens. The national government plays the primary role in law enforcement, particularly in policing. It composed of 5 major law enforcement agencies such as the Philippine National Police, National Bureau of Investigation, Philippine Drug Enforcement Agency, Bureau of Immigration and Deportation, and Bureau of Customs. The second pillar is the prosecution. The prosecution pillar conducts preliminary investigation of cases filed in the prosecutor's office and prosecutes cases filed in the court against alleged offenders after probable cause has been established. It composed primarily of 2 national government agencies, the National Prosecution Service and organic unit of the Department of Justice and the Office of the Ombudsman. The third pillar is the judiciary or court. Judicial power is vested in the judiciary. The judiciary pillar resolves cases and renders judgment. The Philippine judiciary is a four-tiered court system consisting of the Supreme Court as the highest court of the land, the intermediate courts consisting of the Court of Appeals, Sandigang Bayan, and Court of Tax Appeals, the second-level courts, which consist of regional trial courts, and the first-level courts comprising of the metropolitan trial courts, municipal trial courts in the cities, municipal trial courts, and municipal circuit trial courts. The fourth pillar is the correction. Correction is responsible for the welfare and development of the inmates, rehabilitation, jail or prison management, and reintegration. It is composed of two major and equally significant components. First, the institution-based, and second, the community-based corrections. The institution-based corrections are composed of prisons and jails administered by the Bureau of Corrections of the Department of Justice, the Bureau of Jail Management and Penology of the DILG, and the local government units with regard to provincial and sub-provincial jails. Community-based corrections pertain to probation and parole. The Bureau of Pardons and Parole is authorized by law to grant parole to qualified prisoners, whereas the Parole and Probation Administration of the DOJ administers the probation and parole systems in the Philippines. The fifth pillar is the community. The community pillar collectively imposes limitations on individual behavior of citizens that deter criminality and criminal behavior for the common good of civilization and democratic society. It is composed of the non-government organizations, civil society organizations, Commission on Human Rights, Department of Social Welfare and Development, schools, universities, and church or other religious groups. Interrelationship among the five pillars of the Philippine criminal justice system. The formal legal protection system. As aforementioned, the criminal justice system is the mechanism that the society uses to maintain social control or enforce the standard of conduct necessary to protect individuals and the community. This system operates through the pillars of the justice system, which starts with discovering of the commission of the criminal act, investigating and identifying and apprehending suspects, conducting preliminary investigation to establish probable cause and prosecution in the courts, processing of the case in the court, rendering of judgment, and serving of sentence and release after completion of the sentence. Salient points of the procedural steps. First, police investigation. Police investigation is done upon filing of complaint in the police station. Investigation is undertaken through surveillance, interview of persons with knowledge of facts directly or indirectly connected with the offense, entrapment operations, search and seizure and arrest, interrogation of suspects in police custody, and gathering of physical evidence on the case. The police report is prepared and the case is filed with the prosecutor's office within the geographical jurisdiction. Relevant procedural rules in arrest and warrantless arrest, Rule 113 of the Rules of Court, Rules on Custodial Investigation, in Article 3, Section 12 of the 1987 Constitution. It states that no person may be taken into custody except only by virtue of a warrant of arrest issued by a competent court. Arrest without warrant by a peace officer or a private person may only be allowed under the following circumstances specified in the Rules of Court. A. When in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. B. When an offense has in fact just been committed, and he has personal knowledge of facts indicating that the person to be arrested has committed it. And C. When the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment, or temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. Upon arrest, the alleged offender or perpetrator is detained at a police lockup for custodial investigation. By custodial investigation, we mean questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. Preliminary investigation. A preliminary investigation is an inquiry or proceeding to determine whether or not there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Relevant procedural rules. Preliminary investigation of Rule 112 of the Rules of Court, Rules on Inquest, on Article 125 of the Revised Penal Code as amended. Except in these cases of lawful arrest without warrant, a preliminary investigation is required to be conducted before the filing of the complaint or information for an offense where the penalty prescribed by the law is at least 4 years, 2 months, and 1 day without regard to the fine. According to Section 1, Rule 112, Rules of Court. In Arula v. Espino, the court rendered the 3 purposes of a preliminary investigation, to wit, number 1, to inquire concerning the commission of crime and the connection of the accused with it, in order that he may be informed of the nature of and character of the crime charged against him, and if there is probable cause for believing him guilty, that the state may take the necessary step to bring him to trial. 2. To preserve the evidence and keep the witnesses within the control of the state. And number 3, to determine the amount of bail. If the offense is bailable, the officer conducting the examination investigates or inquires into facts concerning the commission of a crime with the end and view of determining whether an information may be prepared against the accused. Issuance of resolution. The finding of probable cause is contained in a document called the resolution. If the city or provincial prosecutor approves of the resolution, then the proper information is filed in the proper court. If the imposable penalty is below 6 years, then the case is filed with the municipal trial court. If the imposable penalty is more than 6 years, then the case is filed with the regional trial court. Filing of information in court. Upon approval of the resolution, proper information is filed in the proper court. The information is a formal accusation or charge against a person who is believed to have committed a crime. If the imposable penalty is below 6 years, then the case is filed with the municipal trial court. If the imposable penalty is more than 6 years, then the case is filed with the regional trial court. Arrest and posting of bail. As previously stated, probable cause for the issuance of a warrant of arrest is the existence of such facts and circumstances that would lead a reasonably discreet and prudent person to believe that an offense has been committed by the person sought to be arrested. Relevant procedural rules. As aforementioned, the judge determines whether or not a warrant of arrest should be issued against the accused. If before issuing a warrant of arrest, the judge must satisfy himself that based on the evidence submitted, there is sufficient proof that a crime has been committed and that the person to be arrested is probably guilty thereof. According to Rule 113, Rules of Court. On the other hand, bail is the security given for the release of a person in custody of the law, furnished by him or a bondsman to guarantee his appearance before any court. Bail may be given in the form of corporate surety, property bond, cash deposit, or recognizance. Bail cannot be posted for custody of the accused has been acquired by the judicial authorities by his arrest or voluntary surrender. According to Rule 114, Rules of Court. Arraignment. One of the first steps of the criminal trial process is the arraignment. Sometimes, an arraignment comes shortly after the arrest and booking of a defendant, when it is typically combined with a bail hearing. Pre-trial. Once the office of the prosecutor has sufficient evidence against an individual, it submits a request to the pre-trial judges to issue a warrant of arrest or summons to appear.
Good day everyone, I'm Giancarlo A. Jaime from BS Crim 15. So for today's video, I'm going to discuss examining the 5 pillars of the Philippine criminal justice. The introduction of examining the 5 pillars of the Philippine criminal justice. In this lesson, we examine closely in details the various pillars of the Philippine criminal justice system. As we discuss each pillar one by one, reflect upon how each pillar connects with your role as an officer or member of the law enforcement community. So guys, what is law enforcement pillars? Law enforcement agencies are organizations and offices of the government that enforce the laws or assist in the enforcement of the law. The law enforcement pillar is the front line of the encounter with criminal or those who threaten the social order. These agencies are generally tasked to prevent crime and maintain peace and order. And now guys, we have 4 parts of agency in the law enforcement pillars. 1. Philippine National Police. The Philippine National Police, PNP, was established in 1987. Its powers and functions are as follows: enforce all laws and ordinances relative to the protection of lives and properties, investigate and prevent crimes, effects of arrest of criminal offenders, bring offenders to justice and assist in their prosecution. Under law of Philippine National Police, it has power to issue license to operate security agencies and supervise training and operation of security agency. 2. National Bureau of Investigation. The National Bureau of Investigation, NBI, was created in 1936 with the enactment of Commonwealth Act No. 181 in 1947. Executive Order No. 94 issued on October 4, 1947. Renamed it to presently known NBI. Its functions were expanded and the power of its investigating staff increases. National Bureau of Investigation tasks mainly in function include assisting in the investigation or detection of crime and other offenses. It also acts as National Clearinghouse of Criminal Records and other information for us of all prosecution and law enforcement entities. 3. Philippine Drug Enforcement Agency. The PDEA is the agency primarily tasked with the enforcement of RA number 9165. The new law also abolished the National Drug Enforcement and Prevention Coordinating Center, Philippine National Police Narcotics Group, PNP, and Custom Narcotics Interdiction Office, CNIO. 4. National Police Commission. The National Police Commission, NAPOLCOM, is an attached agency to the Department of the Interior and local government. It has 7 staff services in its central office and 17 regional offices nationwide as follows: Planning and Research Service, Inspection, Monitoring, and Investigation Service, Crime Prevention and Coordination Service, Legal Affairs Service, Personnel and Administrative Service, and Financial Services. And now guys, what is law enforcement pillar and human rights? The use of force or violence in responding or arresting an accused has always been an issue in Philippines law enforcement agency. All accused are entitled to the presumption of innocence, a fair trial, and respect for dignity and privacy. Arresting an individual is depriving him or her with his or her liberty. Hello guys! What is prosecution pillars? The prosecution pillars is composed of the National Prosecution Service of the Department of Justice, the Public Attorney's Office, and the Office of the Ombudsman. It is tasked with the burden of prosecuting offenses against public officials, as well as individuals accused of committing criminal offenses. Hello guys, I'm back. Under the prosecution pillar, we have 3, which is first, the National Prosecution Service Department of Justice. The National Prosecution Service (NPS) assists the Secretary of Justice in the performance of power and function of the department. The said mandate and present NPS organization are contained in the PD number 1275 as amended and the EO number 292. And the second, the Public Attorney Office. The principal free legal aid office of the Philippine government is Public Attorney's Office. FAO. Lawyers are mandated to handle criminal and civil cases. They also handle labor cases before the National Labor Relationship Commission and administrative matter before various bodies like DARAB, PRC, COMELEC, and PLEB. Office of the Ombudsman. The Irish Government's Office of the Ombudsman for Standard and Privilege can investigate complaint against public official on its own initiative even without a formal complaint lodged before it is inquire into act of public servant based on reports in the media or those which come to its attention through sources other than formal complaints. And to sum it up, the Philippine Criminal Justice System or PCGS is defined as a system or process in the community by which crimes are investigated and the person suspected thereof are taken into custody, prosecuted in court, and punished. If found guilty, provision being made for their correction and rehabilitation. That's all.
The third pillar of CJS, Courts Pillar. Courts Pillar. The Courts Pillar is the entity to which administration of justice is large. It is when judicial power is vested. The Supreme Court is the only constitutional court or the court established by virtue of the 1987 Constitution. The Philippine judiciary contains of 4 levels, with the lower courts being created by statutes. Court, known as the Central Core of the CJS of the Philippines, conduct hearing and judgment. These judicial bodies perform the most sensitive phase in the CJ process. This pillar is in charge of conducting trials or judicial adjudications and imposing penalties if otherwise dismissing or acquitting the case. We have 4 kinds of court. First one is the Supreme Court of the Philippines. A Supreme Court justice hold office during good behavior until he or she reaches the age of 70 years or become incapacitated to discharge the duties of his or her office, and Supreme Court justice is appointed by the President from at least of 3 nominees prepared by the Judicial and Bar Councils. Supreme Court, it is a review court, often referred as the Court of Last Resort. It hears appeals from matters resolved by the Court of Appeals or Regional Trial Courts. It's in a general rule, only legal issues may be submitted as an appeal. It will have a Chief Justice and 14 Associate Justices. When the death penalty is imposed, the case is immediately transferred to the Supreme Court for review even if the accused does not file an appeal. The second one is the Court of Appeals. The CA exercises its power, functions, and duties through 23 divisions, in each composed of 3 members. The court sits en banc for the purpose of exercising administrative, ceremonial, or other than adjudicatory functions. CA, it functions primarily as an appeal court, appellate court, hearing matters appealed to it from regional trial courts. It may examine problems of truth or combine fact and law. The third one is the RTC or the Regional Trial Court. An RTC judge is also appointed by the President from at least 3 nominees prepared by the Judicial and Bar Council. RTC second level courts, it has jurisdiction over matters involving imprisonment for 6 years or more or fine of 6,000 pesos or more, one that is presided over by 722 regional trial court judges in each of the country's regions. The Metropolitan and Municipal Circuit Trial Court or Municipal Trial Courts in cities, a Metropolitan Trial Court or METC shall be created in each metropolitan area established by law. Municipal Trial Court or MTC or Municipal Trial Court in cities or MTCC shall be created in each of other cities or municipalities. A Municipal Trial Court or MCTC in each circuit comprising such cities and or municipalities are grouped together pursuant to law. This is a first level court, acquire authority over cases with a sentence of less than 6 years in jail or fine of less than 6,000 pesos. And lastly, the Sharia District Courts. A Sharia judge is appointed by the President of the Philippines and shall be appointed to serve during good behavior until he or she reaches the age of 65 years or become incapacitated to discharge his or her office, and the sooner remove the same causes in the same manner or ordinary RTC or MTC judges. The Sharia District Courts are courts of limited jurisdiction which shall exercise powers and function in accordance with the PD No. 1083. In addition to the qualification for judges of the Regional Trial Court, the Sharia judge should be learned in Islamic law and jurisprudence. The court provides the victims and the accused a chance to prove their innocence through judicial hearings. People are being detained against their will and spend their life behind bars, thus compromising their human rights. Corrections pillar. This is the fourth pillar of CJS. The branch of the administration of criminal justice charged with the responsibility for the custody, supervision, and rehabilitation of the convicted offender. Correction is seen as the criminal justice system weakest pillar because to its failure to reform and rehabilitate offenders and prevent them from returning to a criminal life. Classification of correction. First one is institutional correction. It is concerned with jails, prisons and penal colonies where the criminal will serve his term. Non-institutional correction, it is concerned with the execution of convicts sentenced outside of an institution. It is often referred to as community-based therapy. Bureau of Corrections or BUCOR under the DOJ. The BUCOR is the primary institution in the corrections pillar that provides full custody and rehabilitation programs for the transformations of insular prisoners, those sentenced to more than 3 years to capital punishment. The mandate of the BUCOR is to rehabilitate national prisoners. BUCOR prohibit inmates from committing crimes while in the custody. Convicts condemned by the courts and sentenced to serve their sentence in prisons. Provisions for detainees' fundamental human needs guarantees that convicts have access to rehabilitation programs for their physical, intellectual, and spiritual growth and create livelihood initiatives that helps offenders make living and improve their abilities while incarcerated. Bureau of Jail Management and Penology under of DILG. The Bureau of Jail Management and Penology was created in 1991 to address the growing concern of jail management and penology problem. Primarily, its clients are detainees accused before a court who are temporarily confined in such jails while undergoing investigation awaiting final judgment and serving sentence promulgated by the Court of Imprisonment for 3 years and below under RA No. 6975, the BJMP mandated take operational and administrative control over all cities, district, and municipal jails. The BJMP rehabilitation programs are divided into 4 categories: livelihood, projects, educational, vocational training, recreation and sports, and religious spiritual activities. These are regularly employed in order to eradicate offenders' criminal patterns and transform them into law-abiding and productive citizens. Parole and Probation Administration or PPA under DOJ is the Parole and Probation Administration, previously called the Probation Administration, was created by virtue of PD No. 968 to administer the probation systems under EO No. 292. The PPA was given the additional function of supervising prisoners who, after serving a part of their sentence, are released a parole or are granted pardon with parole conditions. Boards of Pardon and Parole, originally called the Board of Indeterminate Sentence, the Board of Pardons and Parole or BPP was created under Act of 4103 as amended on December 5, 1933 to implement the provision of the Act which provides for the determinate sentence and parole for all persons convicted by the courts of certain crimes. The BPP is especially tasked with granting parole to qualifying inmates, recommending to the President of the Philippines the issuance of sentence modifications and conditional pardon and the unconditional pardon to ex-convicts and assisting in rehabilitation of paroles and pardon. Corrections pillar is overcrowding and lack of funds to reform incarceration have an impact on the human rights of offenders. In certain jail facilities, inmates are abused by correctional officials. These are some of the challenges those certain offenders confront in various correctional facilities. Community pillar is the last pillar of CJS. Community is considered the most important pillar of crime prevention in the Philippines. The participation of community as one of the 5 pillars of the PCJS is crucial. Institutions such as the barangays, government agencies, legislative bodies, academic and religious and civic organizations are involved in this pillar. pillar, the institutional agencies under the community pillar to be discussed herein include the Department of Social Welfare and Development, the Department of Interior and Local Government, the Commission on Human Rights, and the National Commission on Indigenous People. Department of Social Welfare and Development, or DSWD. The Department of Social Welfare and Development, or DSWD, aims to provide social protection and promotion of the rights and welfare of the poor, vulnerable, and disadvantaged. One of the goods of the DSWD is to provide preventative protection and rehabilitation and development programs and services. Department of Interior and Local Government, or DILG. The DILG plays the essential part in the development of the criminal justice system. One of its goals is to improve the performance of local governments in governance, administration, and social and economic development, which contribute to providing access to justice by the poor, especially women and children. Commission on Human Rights, or CHR. The Commission on Human Rights, or CHR, is established by Section 18, Article 13 of the Philippine Constitution. It has the following powers and function: investigate on its own or complaint by the private party all forms of human rights violations, monitor the Philippine government's compliance with its treaty obligation on human rights. National Commission on Indigenous People, or NCIP, its mandate to protect and promote the interests and well-being of indigenous cultural communities or indigenous peoples with a due regard to their beliefs. Community is the most important pillar in the Philippine criminal justice system. It consists of the groups that are essential in implementing rules and laws of the government. The process of achieving equal human rights to all individuals is not really clear. Budgets are being cut, the minds of the people are being manipulated, and services are being held by the corrupt.
Good day everyone. To begin this lesson, I'm Vincent James C. Hukar. Today, I'm discussing the Lesson 3 entitled Human Rights of the Philippine Criminal Justice System of Unit 4. So let's begin on the definition of terms. Due process. So what is due process? Due process guarantee against any arbitrariness on the part of the government, whether committed by the legislative, the executive, or the judiciary. So let's move on. What is custodial investigation? So custodial investigation is any questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his or her freedom of action in any significant way. So arrest. Arrest is defined as the taking of a person into custody in order that he or she may be bound to answer for the commission of an offense. So let's move on the right to due process. So due process is a guarantee against any arbitrariness on the part of the government, whether committed by the legislative, the executive, and the judiciary. So it was defined as a law that hears before it condemns, which proceeds upon inquiry and renders judgment only after trial. So there are also three human rights protected by this due process clause of the 1987 Constitution. The first one is the right to life. And the second one is the right to liberty. And the third one is the right to property. So there are two aspects of due process. The first one is substantive due process, and the second one is procedural due process. So what is substantive due process? Substantive due process serves as a restriction on the government's law and rulemaking powers. It requires the intrinsic validity of the law in interfering with the rights of the person to his or her life, liberty, or property. So let's move on the procedural due process. So it refers to the regular methods of procedure to be observed before one's life, liberty, or of property can be taken away from him or her. So, procedural due process in a judicial proceeding entails the following. First, there is an impartial court or tribunal clothed with judicial power to hear and determine the matters before it. So, the second one is jurisdiction is properly acquired over the person of the defendant and the over property which is the subject matter of the proceeding. So, the next one is the defendant must be given an opportunity to be heard. And the last one is the judgment was rendered upon lawful hearing and based on evidence adduced. The right against illegal searches and seizures. So, the origin and history of the right clearly showed that it was intended as a restraint upon the activities of the sovereign authority and was not intended to be a limitation upon other government agencies. Search warrant. So, for a valid search warrant to issue, the following must be present. First, existence of probable cause. And the second one is determination of probable cause was done personally by the judge. Number 3, personal examination under oath or affirmation of the complainant and the witnesses he may produce. And 4, personal knowledge of the complainant or his witnesses of the facts. And 5, particular description of the place to be searched and the person or things to be seized. Warrantless searches and seizures. So, in searches and seizures can only also be conducted validly without a warrant. So, Philippine jurisprudence states several circumstances to wit. First, searches of moving vehicles. Second, body checks in airports. 3, stop and frisk. 4, inspection of building and other premises. 5, consented warrantless searches. And 6, incident to lawful arrest. 7, visual search at checkpoints. And 8, aerial target zonings or situation drives. 9, exigent circumstances doctrines. And 10, plain view doctrine. So, the plain view doctrine is usually applied where the police officer is not searching for evidence against the accused but nonetheless inadvertently comes upon an incriminating object. In People vs. Bolasa, on December 22, 1999, the elements of the plain view doctrine are enumerated to it. First, there must be a prior valid intrusion based on a valid warrantless arrest in which the police are illegally present in the pursuit of their official duties. Second, the evidence was inadvertently discovered by the police who have the right to be where they are. 3. The evidence must be immediately apparent. And 4, plain view justified more seizures of evidence without further search. So, however, intrusion into the premises without permission from the owner or occupant is permissible when, first, a party whose premises or is entitled to the possession thereof refuses upon demand to open it. So 2, the person in the premises already know of the identity of the officers and of their authority and persons. 3, the officers are justified in the honest belief that there is an imminent peril to life or limb. And 4, those in the premises aware of the presence of someone not outside are then engaged in activity which justifies the offense to believe that an escape or the destruction of evidence is being attempted. So, let's move on the rights of suspects under custodial investigation. First, right to be informed of his right to remain silent and to conceal. So, this right carries the obligation on the part of the investigator to explain and contemplate effective communication which results in the subject understanding what is conveyed. So, number 2, right to be reminded that if he wants his right to remain silent, anything he says can and will be used against him. So 3, right to remain silent. And 4, right to have competent and independent consent, preferably of his own choice. So 5, right to be provided when concealed if the person cannot afford the services of one. So 6, no torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. 7. Secret detention places, solitary, and incommunicado or other forms of detention are prohibited. 8. Confession or admissions obtained in violation of these rights are inadmissible as evidence. So on Section 2 of RA number 7438 provides for the requisites of an admissible extrajudicial confession to wit. First, it was made by a person arrested, detained, or under custodial investigation with assistance and in the presence of his counsel or in the latter's absence upon a valid waiver and in the presence of any of the parents, elder brothers and sisters, his spouse, the municipal mayor, the municipal judge, district school supervisor, or priest or minister of the gospel as chosen by him. Otherwise, such extrajudicial confession shall be inadmissible as evidence in any proceeding. So 2. The confession must be in writing. 3. The confession must be voluntary. And 4. The confession must be expressed and must be signed. Let's move on Miranda Doctrine rights. So first, the person in custody must be informed at the outset in clear and unequivocal terms that he has a right to remain silent. So 2. After being so informed, he must be told that anything he says can and will be used against him in court. 3. The right to consult with a lawyer and to have a lawyer with him during interrogation. So 4. If he is indigent, a lawyer will be appointed to represent him. 5. Even if he consents to answer questions without the assistance of counsel, the moment he asks for a lawyer at any point in the investigation, the interrogation must wait until an attorney is present. So 6. If the foregoing are not demonstrated, no evidence obtained can be used against the person in custody.
Rights against unlawful arrest. Background. Arrest can be defined as the taking of a person into custody in order that he may be bound to answer for the commission of an offense. Under Section 5, Rule 113 of Rules of the Court, arrest can be effected into two modes. 1. Arrest by virtue of a valid warrant, and 2. Arrest without a warrant under exceptional circumstance as may be provided by statute. According to the statement of Section 5 Rules 113 of Rules of Court, arresting people have two modes, which is arresting a people who have a big cases can be given a warrant that Miranda rights can be speak for them. When they gonna already arrested and arresting without any warrant that Miranda rights gonna speak, but you are included on the warrant of arrest because you are accomplice. That's why you gotta want to be arrested that status will provided.
Issuance of a warrant of arrest, effecting an arrest. Under Section 2, Article 3 of the 1987 Constitution, no warrant of arrest shall issue, except upon probable cause to be determined personally by the judge after examination, under oath or affirmation of the complainant and the witnesses, may produce and particularly describe the persons to be seized. The issuance of a warrant of arrest is defined as such facts and circumstances which would lead reasonably distract and prudent man to believe that an offense has been committed by the person sought to be arrested. The under of Section 2, Article 3 of the 1987 Constitution says that if you will gonna arrest somebody without any legal documents like warrant of arrest, gonna be biggest issue. But on any probable causes, the judge itself gonna examine a person who gonna be under law or judge affirmation about the complainant that witnesses gonna down inside of the court's judgment. They will gonna know the person's reactions gonna describe the disease. That's why the issuance of a warrant of arrest designed as good or bad because of the circumstances will lead into zigzag reasonable things that gonna be offensive. That's why we need to spill and say the Miranda rights into a person that would be defendant because of the case of being arrested. A lawful arrest. No violence or unnecessary force shall be used. The person arrested shall not be subjected to a greater restraint than necessary for his detention. The following may be confiscated: objects, subject of the offense, or used or intended to be used in commission of the crime. Number 2, objects which are the fruits of the following crime. 3, those which might be used by the arrested person to commit violence or to escape. 4, dangerous weapons and those which may be used as evidence in the cases. And the last, objects, the possession of which is illegal. First, this law of arresting the defendant that no shows any violence or any forces that the law or the enforcement gonna do. The restraint may not subjected when he was arrested to put him into detention or custody and to be silenced. The objectives from 1 to 5, that a person cannot bring any things that can cause crimes inside the prison, that they used to do dangerous things, that being a reason why they become restraining inside of a detentions. Execution of a warrant of arrest. The judge issues of warrant of arrest in 2 instances. 1. Upon filing of the information by the prosecutor, the judge merely evaluates personally the report and supporting documents and other evidence adduced during the preliminary investigation and submitted to him by the prosecutor, and if he finds probable cause on the basis thereof, he issues the warrant for the arrested of the accused. This execution from the word executed, which means they will gonna do. These things gonna be executed when the persons that arrested had formal documents that shows evidence against the person. This will be passed to the enforcement of investigation that the prosecutor itself find the true reason in crime and to arrested person, and that's why execution of warrant arrest gonna pass and will out upon application of a peace officer. The contrary, in this case, the judge must personally examine the applicant and witnesses he may produce to find out whether or not there exists probable cause. He must subject the complainant and the witness to searching question, unlike a search warrant, the validity of which is 10 days and becomes void thereafter. There is no time limit for the validity of a warrant of arrest. This contrary will be part of a peace for the person who be abused by the suspect. If they wanted to be peace without any trouble, shooting inside the court and enforcement. The person who wants peace is the person who did not commit the crime, and the crime cannot be open and have a trouble in contrast because they believe that the person was unguilty. Warrantless arrest. General rules: no peace officer or person has the power or authority to arrest anyone without a warrant, except in those cases expressly authorized by the law. The following instance in flagrante delicto arrest and doctrine for hot pursuit. Granted delicto arrest cover the provision under Rule 113 of the Rules Court, stating that A warrantless arrest can be had when he presents the person to be arrested has committed, is actually committing, or is attempting to commit an offense. The person who arrested and accused is apprehended. May says from 1 to 2 following that requisites data claim that a person should be arrested who commit or attempt should be pronounced the Miranda rights. For this to happen in flagrante delicto arrest, the case of Hombre v. Pupo enumerated 2 requisites. 1. The person to be arrested must execute an overt act indicating that he has just committed, is actually committing, or is attempting to commit a crime. And 2. Such overt act is done in the presence or within the view of the arresting officer. Bypass operation is a form of entrapment that has been repeatedly accepted to be a valid means of arresting violators of the dangerous drugs law. Bypass operation that the enforcement arresting a dangerous crimes like inside of a drug laws.
The doctrine of hot pursuit also follows the provision under Rule 113 of the Rules of the Court, stating that the warrantless arrest can be had when an offense has in fact just been committed, and the peace officer or any private person has probable cause to believe based on personal knowledge of facts and circumstances that the person to be arrested. For this to happen, jurisprudence states the following requisites. 1. An offense has just been committed. The time interval between the actual commission of the crime and the arrival of the arresting officer must be brief. 2. Probable cause based on personal knowledge. Mere intelligence information that the suspect committed the crime will not suffice. An offense has just been committed says that the time interval of crime committed must be interval to the arrival of the officer who's gonna be briefing. Probable cause based on personal knowledge. The situation of the information that the suspect committed the crime and it was shown on the evidence that will not suffice, the other evidence will be covered. Evasion of service of sentence pertains to the arrest to be made against the prisoner. 1. He escaped from a penal establishment or place where he is serving final judgment or temporarily confined. 2. Has escaped while being transferred from one confinement to another. This is founded on the principle that at the time of the arrest, the escape is in the continuous act of committing a crime. This topic talked about the person who's arrested was being escaped. On the number 1, the prisoner escaped from the establishment of the place he or she detained. On number 2, the person committed another crime to be escaped while being transferred by a mobile of enforcement, and he escaped by doing another cases of crime.
Lesson 4. Human rights in the Philippine criminal justice system. Right of the accused, right to bail, right against excessive fines and cruel and inhuman punishments, and right against double jeopardy. The lesson objectives. Number 1. Discuss the rights of accused, right to bail, right against excessive fines and cruel and inhuman punishment, and right against double jeopardy. Number 2. Discuss the important principles, concepts, and matters relevant to these rights. Introduction to Lesson 4. In previous lesson, we started discussing the specific aspect where criminal justice and human rights intersect due process, custodial investigation and arrest, and the various principles and rights within this aspect. In this lesson, we will continue discussing other rights of the accused, as well as the rights to bail, rights against cruelty, and rights against double jeopardy. There are 12 rights of the accused that were discussed. These rights are the following. First, right to be presumed innocent in all criminal prosecution. The accused is presumed innocent until the contrary is proven beyond reasonable doubt. Second is right to be informed of the nature and the cause of the accusation against him. An accused cannot be convicted of an offense unless it is clearly charged in the complaint of information. The third one is the right to be present and defend in person and by counsel at various stage of the proceeding. The presence of the accused during the criminal action is not required and shall be based on his sole discretion. Fourth right to conceal. The court has the affirmative duty to inform the accused of his right to conceal and to provide him with one in case he cannot afford it. Fifth right is to testify as witness in his own behalf. A denial of the right of the accused to testify on his behalf would constitute an unjustifiable violation of his constitutional right. Sixth right, to be exempt from being compelled to be a witness against himself. Seventh right, self-incrimination. Eighth right of the accused in the matter of testifying or producing evidence. Right to confront and cross-examine the witness against him at trial. The purpose of confrontation is to secure the opportunity of cross-examination and for the judge to observe the demeanor of the witness. 10th right to have compulsory process. This is the right of the accused to have a subpoena or subpoena ducis tecum issued in his behalf in order to compel the attendance of witnesses and the production of the other evidence. 11. Right to have a speedy, impartial, and public trial. And 12. Right to have to appeal on all cases allowed by law and in the manner prescribed by law.
Right to bail. What is bail? According to Section 1, Rule 114, Rules of Court, bail is the security given for the release of a person in custody of law, furnished by him or a bondsman, to guarantee his appearance before any court as required under condition specified under the Rules of Court. The right to bail is available to persons detained or under custody of the law, either when he has been arrested or has surrendered himself or herself to the jurisdiction of the court. In Tagalog, the bail is what we call fianza. There are 4 forms of the bail: the corporate surety, property bond, cash deposits, and recognizance. We are already knowledgeable about it, so I will not explain it anymore. When bail is a matter of right. Bail is a matter of right if the person is charged with an offense is not punishable by reclusion perpetua or life imprisonment or death. Bail when discretionary. Upon conviction by the regional trial court of an offense not punishable by reclusion perpetua, the court on application may admit the accused to bail. If the court imposes a penalty of imprisonment exceeding 6 years but not more than 20 years, the accused shall be denied to bail, or the bail previously granted shall be cancelled. No person charged with a capital offense or an offense punishable by reclusion perpetua shall be admitted to bail when evidence of guilt is strong regardless of the stage of the criminal prosecution. That is according to Section 7, Rule 114, Rules of Court. Hence, bail is neither a matter of right nor a matter of discretion. Bail is deemed automatically cancelled upon the following: 1. Acquittal of the accused, 2. Dismissal of the case, or 3. The execution of the judgment of conviction. That is according to Section 22 Rule 114 Rules of Court. When bail is a matter of right, before or after conviction by the MTC or before conviction by the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment, and before conviction by the RTC of an offense punishable by death, reclusion perpetua, or life imprisonment, but the evidence of guilt is not strong. When bail is discretionary, after conviction by the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment. When bail shall be denied, before conviction by the RTC of an offense punishable by death, reclusion perpetua, and the evidence of guilt is strong. After conviction of the RTC of an offense punishable by death, reclusion perpetua, and the presence of bail, denying circumstances under Section 5 Rule 114 of the Rules of Court, and after conviction by the RTC of an offense punishable by death, reclusion perpetua, or life imprisonment. Excessive fines and cruel and inhuman punishment. A fine is considered excessive when it is clearly shown that the nature of the violation compared with the fine is disproportionate, or if it exceeds the utmost limit of the punishment, which the indication of what the law demands. Is according to U.S. v. Valera. To violate this right, the penalty must be flagrant and plainly oppressive, disproportionate to the nature of the offense as to shock the senses of the community. This is according to People v. Istuesta. The cruelty against which the Constitution protects the convicted man is cruelty, inherent in the method of punishment, not the necessary suffering involved in any method employed to extinguish life humanely. This according to Ichigaray v. Secretary of Justice. Notably, Republic Act No. 9346 prohibited the imposition of death penalty. Republic Act No. 9745 prohibited the use of torture as punishment to ensure that the human rights of all are respected at all times. Right against double jeopardy. When an accused has been convicted or acquitted, or the case against him dismissed or otherwise terminated without his express consent by a court of competent jurisdiction upon a valid complaint or information or other format charge sufficient in form and substance to sustain a conviction, and after the accused has pleaded to the charge, the conviction or acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for the offense charge, or for any attempt to commit the same frustration thereof, or for any offense which necessarily includes or is necessarily included in the offense charge in the form, complaint, or information that is according to Section 7 Rule 117 Rules of Court. The rationale of this right is that the full power of the state is ranged against the accused if there is no limit to attempt to prosecute the accused for the same offense after he has been acquitted. The infinite power and capacity of the state for a sustained and repeated litigation would eventually overwhelm the accused in terms of resources, stamina, and the will to fight. It is according to Lihano v. People. For double jeopardy to apply, a previous case must be filed and must contain the following: 1. A valid complaint or information. 2. This complaint or information must be filed before a competent court. 3. In this court, the accused has pleaded. 4. Accused was previously acquitted or convicted, or the case dismissed or otherwise terminated without his express consent. That is according to People v. Ilagan. The crime covered in double jeopardy are the following. 1. Same offense or attempt to commit or frustration thereof, or for any offense which necessarily include or it is necessarily included in the offense charged in the original complaint or information, and when an act is punished by law and an ordinance, conviction or acquittal under either shall bar another prosecution for the same act.